Good afternoon, everyone. Nice to see all of you still there. I spoke to you in the morning and it was nice. So, we have the last session now for the day, and the topic is arbitral practice and advocacy. And I was just telling my co-panelists that we kept the best session in the last so that you all can have a most interactive session, and whatever your doubts are from the morning or otherwise, you can get it clarified from the expert panel we have. So we are fortunate to have excellent panel today. To my extreme left, we have Mr. Gaurav Pachnanda. He is a senior advocate and he appears in constitutional matters as well as arbitration matters. He is expert in handling quite a few arbitration matters. To my left is Mr. Ratan Singh. He is fellow of Chartered Institute of Arbitrators UK. He is the chairperson of Society of Construction Law. He regularly sits as arbitrator and also act as a counsel in quite a few arbitration matters. To my right is Shashank, very dear friend and partner with Advani and Company. He's expert on arbitration matters again and acts as an arbitrator and counsel. And last but not the least, Manmeet, again a very good friend and advocate who practices on original side as well as on arbitration matters, and she appears regularly in arbitration related work. So with that, we will start the panel discussion, and we would give you an overview of what's the difference between the arbitral advocacy vis-a-vis the traditional litigation practice. So if we can start with views from Mr. Singh, what's your view as far as arbitral advocacy goes, and how is it different from typical litigation practice as we normally call in court practice? No, we can do it from.
Good afternoon. Arbitration advocacy is an interesting topic. What is that we understand about arbitration advocacy? What does it really mean? To me, arbitration advocacy is all about being in control of an arbitral proceeding. Your effort as arbitration advocate, lawyer, is to be in control of the arbitration proceeding. In fact, 2 months back, I was speaking in one international conference, and there I had said that arbitration is as good as arbitrator. I strongly believe that it is also equally true that arbitration can be as good as the arbitration lawyer. You can be in control of the proceeding. You can be in control of the arbitration as a process of dispute resolution from the very beginning. From the stage when arbitration agreements are written, you can anticipate the disputes which may come up depending on the nature of the contract. You can think of the arbitrator, potential arbitrators. If it is a construction contract, why should you know it? Write in your arbitration contract, arbitration agreement, that arbitrator must have experience of construction industry or construction law for that matter. When it comes to conduct of arbitration proceeding, I would say here, topic essentially is similarities or dissimilarities between arbitration and litigation advocacy. If you look at typical litigation, it is essentially all about civil procedure code. Civil procedure code is meant for all civil disputes across the country, irrespective of the nature of the dispute, irrespective of the parties involved. So you have a standard procedures prescribed in civil procedure code. All disputes, all litigations have to run through all those procedures which are there in the CPC. But when it comes to arbitration, CPC, as we know, CPC doesn't apply. What does it mean? You need to know what are the options available to lawyers, arbitration advocates, and to the tribunal. What all they can do which would be different from or similar to the litigation. For that, particularly when we talk about Indian context, in India most of the arbitrations are dominated by lawyers or judges, retired judges. So here they talk in terms of CPC, they talk in terms of Indian Evidence Act. So it is important for all of you to know what CPC is, how typical litigation works, so that you can understand, if you know CPC, then you can understand what all of CPC will not work in arbitration. Just for an example, if you have a court litigation, you start from filing of plaint, written statement, documents are exchanged, admission denied, framing of issues, examination in chief, cross-examination. And then you go for final arguments. Recently, I was doing one arbitration as I was the presiding arbitrator, big construction dispute. I directed all the parties that on the very first day, I would like to hear both sides for 20 minutes each, on what is the dispute all about. Why cannot you ask the parties to come and tell you what is the dispute, essentially? Then you can run, so that tribunal understands what are the real disputes between the parties. Parties can understand each other's case, so that whole process of case management, arbitration management becomes easier for you. So here in arbitration, there is nothing fixed. It is all about knowing what is ideally suited for your dispute, which is in arbitration. Now, when we talk about being in control of the arbitration proceeding, two things I would say is very, very important for all of you to know. One is that you must know how to write briefs, how to write written submissions, starting from the notice for arbitration, pleadings, witness statements, post-hearing briefs, pre-hearing briefs, how to write them. And for that, I would say that you must know Order 6, Order 7, and Order 8 of CPC. That really gives you good guideline as to what all should be written in a particular pleading. Obviously, you are not bound by that, but there you get some guideline. Your Arbitration and Conciliation Act doesn't tell you how to write your pleadings, how to deny a particular argument made in a plaint or a statement of claim. So writing brief in plain English, simple English, small sentences, small paragraphs, going by headings, going by subheadings, knowing the whole case and writing the gist of the case in one paragraph, making the life easier for the arbitrator, is the art of writing right briefs. When it comes to oral submissions, before that, one thing is, another important aspect is cross-examination, which is very common in arbitration. Cross-examination, in fact, we had an event where we said art of cross-examination. We call it art of cross-examination. The question sometimes asked is whether we can call it art of cross-examination or science of cross-examination. Rather, it is both. Similarly, somebody asked me, can you teach can you teach arbitration advocacy? Can one teach arbitration advocacy? Answer is essentially no. To a certain extent, yes, but otherwise it is all about observing the proceeding, being part of the proceeding. So if you witness the proceeding, if you witness how things work while working with somebody, it really teaches you in a better way. But we should also attend these kind of events where we get to know from each other what are the real issues involved in that. Cross-examination is one aspect. You should be very careful. You must have this theory in mind of cross-examination, and thereafter you can go for the observing the cross-examination done by people who are otherwise good in cross-examination. And final submissions. Again, one thing, I have 5 minutes, I think. I have lost 5 minutes. Another thing we should be very clear in your mind is from very beginning that you must be cooperative in whole arbitration proceeding, because arbitration proceeding runs as per the procedures agreed by and between the parties and the procedures decided by the tribunal, who again takes you into confidence. So here, how cooperative you are with the other side, with the tribunal, that really matters, because ultimately it is all about your personality, how you conduct yourself in arbitration proceeding. You should never be arrogant in arbitration proceeding, because please appreciate, arbitrators are human beings. You should not rub them on wrong side. So these are some of the fundamentals you should keep in mind, and then I give it to Tejas so that he can invite other speakers.
Yeah, okay. Thank you. This was a lot of insight into how to conduct yourself in arbitration proceedings. And as you rightly said that you know how to write briefs, because it's very important. Written advocacy is as important as oral advocacy. And if I can ask Mr. Pachnanda, he's a senior counsel and he appears regularly in arbitration matters. And when you get briefed as a counsel, and the briefs are drafted obviously by the advocates, how do you see that the importance of written advocacy is also valuable when you are arguing a case? Because in arbitration is all fact intensive, we really rely on the facts and try to prove certain things. So advocacy, written advocacy for pleadings as well as witness statements and sometimes expert testimony is very important. So what are your views in terms of written and oral advocacy?
So I think to understand, I think from a counsel's perspective, to understand the difference between advocacy in court proceedings and advocacy in arbitration. And of course, when you come to advocacy in arbitration, the difference between written advocacy and oral advocacy, I think it's very important to understand a few peculiar features of an arbitration hearing. First of all, an arbitration hearing is being conducted by an arbitrator who's entirely dedicated to this one matter for a fixed period of time. So if he has given you a hearing for 2 hours, for 2 hours the arbitrator or a tribunal is committed to this one matter. Number 2, he's paid to hear you. Number 3, his overarching obligation is to make sure that he's giving a fair hearing to both sides. So to that extent, if it's possible, unless you really push the arbitrator to the wall, the arbitrator will not cut you short. He will try to give you a fair hearing, try to give both sides a fair hearing. The third point is, it is a private hearing. So in that sense, it is not the same as arguing before a court with 200 lawyers sitting behind you, which can cause huge embarrassment if you've sort of put your foot on the wrong side. And often, if the tribunal might be as new to the substance of the dispute as you are. For example, an intricate construction matter, often you come across construction experts, but often, equally often, there'll be judges who may be involved, very well versed with legal principles, but the substantive matter is something as new to them as it is to the counsel. Now, all these things make arbitration a very interesting but a unique forum. It allows you to to be fully prepared and also display the extent of your preparation. But it can also make you a bit sloppy. In court, when you're before a judge who more often than not is very well versed with the matter that is coming before him, is under pressure to get on to the point and then move on, often you will be on your toes, and you would perhaps be, you would get a greater opportunity to sharpen your skills of advocacy. I think the problem with these unique features of arbitration is to make sure that you're very disciplined and you do not end up as counsel taking an unfair advantage of this situation and landing up in a sloppy position of advocacy. So if you have 2 hours, it doesn't necessarily mean that you have to meander for 2 hours. You still have to get to the point. Do not take advantage of the arbitrator's patience. Try to be on to the point, move on, explain the questions that the arbitrator has, and then sort of be very focused. So in that sense, I have always believed that court advocacy often provides best training, even for arbitration advocacy. But having made that point, what is the difference between written advocacy and oral advocacy in arbitration? There is a substantial change that is now taking place in our country, although this is something that has always been there in international arbitration. The trend before 29A of the Arbitration Act was enacted and we had a cutoff date of concluding an arbitration within a fixed period, the trend was that the arbitrators, often arbitrators were former judges, they would land up to a hearing with a hearing half prepared, sometimes blank. You would take them through the oral, by virtue of oral submissions, you would take them through your case. As a result, the oral hearing would be 2 sittings to 10 sittings to 15 sittings. And then they would ask you to put in your written submissions. So therefore, you could formulate, remodulate, modify your submissions by the time you put in your written submissions. The practice internationally, and which is now the practice picking up in India as well, because the arbitrators are under pressure to finish an arbitration within a fixed period of time, the practice internationally is that your written submissions should be a well-articulated, detailed submission of what you want the arbitrators to consider. It should be filed well before the oral hearing, so that the tribunal does not come to the hearing not having read the material. So often you will supplement a written submission with a core bundle of documents that you want the arbitrators to go through. The standard good practice in arbitration is that the arbitrators are supposed to be ahead of you as counsel, and therefore if the regime is followed in this manner, you will have a detailed written submission, very focused. It doesn't necessarily mean that it should be all over the place. The arbitrators would have read the written submissions, and when they come to the oral submission, they will give you a short while to sort of make a point or two, but basically a large part of the oral submission would be spent in addressing questions that come from the arbitrators because they have read your written briefs and the core bundle of documents. So therefore, in my experience, I think the more forward-looking practice is to rely more on written advocacy, particularly in very high-value disputes where there's a lot of evidence to go through. Make sure that the written advocacy precedes the oral advocacy so that the oral advocacy part does not become unnecessarily prolonged, is focused, and it supplements sort of your written advocacy or your written submissions. If you try to do it the other way, in my experience, it often becomes quite open-ended and results in a lot of wastage of time. Those are essentially my views on the difference between written and oral advocacy.
I think just to add to what Mr. Pachananda said, one of the basic principles that all of us know in arbitration is that arbitrator is the master of evidence and master of facts. It's very difficult for you to argue new points, bring in anything fresh at the stage of challenging an award. So you don't want to give that chance to your case. Therefore, the written part of the advocacy in arbitration is extremely important, that everything that you wish to put forth is there in your written arguments. Whether arbitral tribunal is well equipped, as Mr. Pachananda said, that the presumption is that they are usually well read. That may not be the case always. But you don't want to take chances. Even if there is a bad award, you at least have put everything in front of the tribunal so that that can be used if at all you have to challenge an award.
Yeah, thank you, Shashank. All very valid and important points, because now we see that when we go for a 7-day hearing in London or Singapore, the first thing the arbitrators tell us is that consider that we have read each and everything which you have filed. And we start with 30 minutes opening submissions, then we go into the cross-examination, and we end with 30 minutes closing submission. And there is a heavy reliance on the written materials which we file before the arbitrator, and that is the key. So it's extremely important now how brief we are, and we can't keep writing, it is submitted and is pertinent to note, and then write long paragraphs which continues for pages. We have to be very brief, short sentences and short paragraphs, which is what is appreciated by the international tribunal. So written advocacy plays a very important role. And sometimes I remember my first arbitration where I started drafting a statement of claim. My partner had said it was around 45 pages. So my partner said, make it 20 pages. And I took 1 month to reduce 40 pages to 20 pages, because I didn't know what to cut, because I thought everything was necessary. So what you can say in one sentence, and you should not write one paragraph for that. That's very important. And actually we won the arbitration. And I was really worried that with 20-page statement of claim, whether we will win the arbitration with 3 QCs and Indian law governing arbitration, and we actually won. Of course, we supplemented it with written submissions after the cross-examination was done, but you don't need to say more than what you are required to say. So that is a very important aspect in arbitration, which we normally don't realize when we are drafting plaints or normal civil litigations. So having said that, arbitration is again, a lot of things is said about arbitration being expensive, it takes time, and we should try to reduce the cost and time, because that's the virtue of arbitration. And that's why sometimes when we compare arbitration versus litigation, we see that arbitration is preferred because it saves time and cost. But there are techniques. If we don't get the techniques right, it may not be that productive, and we just end up doing the arbitration in a litigation way. So if I can ask Manmeet to share her thoughts on how best we can follow certain good practices which can in turn reduce the time and cost when it comes to an arbitration process.
Good afternoon. I couldn't agree more with all these panelists that written advocacy plays a very important role in arbitration. In fact, it plays a very important role even in a court litigation, because in my experience, I have noticed that if my pleadings are drafted well, and you are fortunate to have a judge who has read your brief and come, it only takes a 10-minute hearing in court, because the advantage of the written advocacy has been that the judge has not only been able to appreciate your facts, but also the principles of law that you have applied to it. And you could have won and succeeded in your appeals, which otherwise would take you very long in an oral submission, including the court hearing. Now, how does one apply that to arbitration, and how does one make that different from litigation? One of the important things I learned by experience, which I did not implement earlier, was that when your client first approaches you with his dispute, we usually take it very lightly and we proceed with the matter. We simply issue a notice invoking arbitration, reserving our rights to raise our claims at a later stage. But instead, if at the first instance itself, the lawyer was to approach his client, collate the facts, collate the documents, understand the exact nature of dispute he's facing, and in fact, the request for arbitration itself, if it gives a precise narration of facts and raises the statements of claims while reserving rights for additional claims, it sets the ball rolling on day one itself. Because time is why your client opted out of the court litigation. And you could save him this time on the first day when you issue the notice itself. Because when his opponent is put to notice of this sequence of facts and statement of claims, he's compelled to respond to it, also probably set out his own counterclaims. At this stage, when both parties have put their notice in place and resulted in selecting an arbitrator of their choice, the arbitrator also, who has received the notices and the copies of the reply, is in a position to know that what is the kind of arbitration and the reference that he's receiving. That is where Mr. Singh when he said, when the first hearing at the arbitration happens, which is the case management hearing, the arbitrator is already well aware that what is the scope of the disputes his parties want him to determine. At this stage, again, a lawyer plays a very important role. If he has actually interacted with his client and understood the scope of the documents and the claim, he can assist the arbitral tribunal. What is a case management hearing? It is the first hearing when both the lawyers inform the arbitrator what are the steps they are expecting at the hearing. That they are expecting to file a claim, a reply, lead evidence, have documents discovered from each other. And if at that time the lawyer has made a real-time assessment of his client's claims, both the lawyer for the claimant and the respondent, they are in a position to advise the tribunal on the time they will take. Thereafter is the lawyer's discipline to stick to that timetable which he agrees with the learned arbitrator. If the lawyers and the arbitral tribunal, of course, enforces that timetable, parties can actually result in having an effective time-managed dispute resolution for their client, which was in the first instance why he opted for the arbitration. Because that is what the claimant at least opts for, is because he wants a time-bound resolution. Because his only opposition to a court-driven litigation is that the rule of law prevails, but justice comes very delayed to him. But in arbitration, he's willing to compromise a bit on the procedural aspect and have a dedicated arbitrator at higher cost so that he gets a faster resolution. And a lawyer is all the difference it makes. That's where when Mr. Ratan Singh said that he believes in arbitration is what the arbitration lawyer is very significant. That it is the lawyer's own sense of discipline on how he's going to drive his client's matter makes a difference. So another important thing is that lawyers need to have time when they take up arbitration briefs. For instance, I had read somewhere Mr. Karya had mentioned in a separate litigation that a lot of lawyers who attend court treat arbitration as a secondary choice. They attend arbitrations in evening sessions. That's changing a lot. Mr. Karya, for instance, is a very dedicated arbitration practitioner. So is Mr. Pachnanda and Mr. Singh, everybody here on the panel. I think that's also a conscious choice which all of you young lawyers will have to make, that, gone are those old days where we could sail in both the boats, that during the day I attend court hearings and in the evening I'm with the arbitrations. It's certainly a choice that lawyers will have to make. But they're also, like Mr. Pachnanda said, that maybe a court-trained lawyer who eventually opts out for an arbitration bar choice will probably be a more informed choice for him. But I think a lot of commitment will have to come from lawyers, and we need to understand what is very different from the court litigation is that the commitment to the brief has to begin on the day when the client approaches you to start this proceeding. And having said that, there's another aspect which we lawyers sometimes lose view of, is arbitration clause limits the jurisdiction of the arbitrator. An arbitrator can only decide what by parties have by contract decided to permit him to. So if you are one of those lawyers who's drafting the arbitration clause, you also have a very important role to play in case some of you decide to be the lawyers who have actually drafted the contract. Being very clear and precise on what are the disputes in your arbitration you want to be referred to the arbitrator would go a long way in not letting parties meander around and refer disputes which were not intended. So also selection of the qualification of the arbitrator. As Mr. Ratan Singh pointed out, in some contracts, probably you want industry experts. Probably it's a gas supply contract, it's a construction contract. You actually want engineers to decide it because the facts require them to be there. Selection of your arbitrator goes a very long way in having a fast-track arbitration. So even when you are a lawyer who's drafting the contract, I think how clear your arbitration clause is, how specific you are, how you set out the jurisdiction of the arbitrator goes a long way. Now switching back to the lawyer who's going to arbitrate, you must be mindful of the jurisdictional clause in your arbitration. Please do not raise claims which you know are bound to fall outside the arbitration clause, because not only will you waste the time of the arbitrator in getting him to return a finding that I can't entertain this claim, or in case he commits the fallacy and does arbitrate your claim, then the court will have to set it aside. So also please be very honest in your appreciation of your arbitration clauses and advise your client whether his dispute falls within arbitration or not. So I think a lot rests on the initial homework a lawyer does, which begins with client meeting and the written advocacy. The oral advocacy, yes, all you lawyers that is what we all lawyers think when we go to law school, that the only thing we think of is arguing and persuading the judge and winning an argument. But all of that will only happen once you have built the facts, because good language cannot replace facts which only your client can tell you through the process of interaction with the client. So time efficiency will have to begin when you will find time for the client. I would like to just end with one thing. I heard an anecdote where someone said, I'm writing to you a long letter because I don't have time. If I had time, I would have written a short letter to you. Because as Mr. Karya said, that in fact, when he mastered the facts, the statement of claim came down from 40 to 20, because that's how precise it could be. So I would only request all of you to find that time to write the short letter and not write the long letter to the arbitrator. Thank you.
Thank you. A lot of practical tips there, and I know, because ultimately it all comes with experience, and we have to start focusing from the early days so that we can learn these tricks of the trade very quick, and be known as specialist in whatever you are doing, as I was saying. But as all young lawyers, we all want to try something different, and we want to try everything before we specialize into particular field. So what are the avenues if we ask, if someone wants to specialize in an arbitration field? Shashank, what's your view? Because you primarily do now a lot of arbitrations, and you do other matters as well, but I've always seen you in arbitration related matters. So do you think it's worthwhile for young lawyers to specialize in arbitration in early days, or should try everything for 2-3 years and then specialize? Or sometimes we are asked that why should I do only this when other colleagues or other friends are doing everything, civil, criminal, competition. Everybody should learn something and then specialize. So what are the avenues for young lawyers in the field of arbitration?
So to answer your question, I'll split your question into two parts. First is why, and then is how. So first we need to answer why arbitration. In words of Professor Martin Hunter, who visits India very often, he says that international commercial arbitration is a bug which has infected many students worldwide without a known cure so far. So the idea is that, are we all moving towards arbitration as young lawyers because it has become fashionable and trendy? Because 10 years, 15 years back, I remember the intellectual property right and information technology were the in things. Every young lawyer had aspiration to become an IP expert. And in the last decade, that trend has changed, and we are seeing that a lot of lawyers now want to, or young students want to practice arbitration or take up arbitration as a career choice. Very often interns who come to my office and show keen and deep interest in pursuing a career in arbitration, I tend to ask them the reasons behind this, this typical choice, or how are they so focused so early in their career. Being focused is not a bad thing, but sometimes when we get focused, we block our avenues to look at other areas of law which may be more suitable to us. So firstly, you need to see what your aptitude is. Are you cut out for something like dispute resolution? Many young students also feel that arbitration is possibly the glamorous version of litigation. So in litigation, the stories that you hear from your seniors or from practitioners, there's a lot of struggle in the beginning. There's hardly any salary, the stipends are peanuts, etc. However, if you do arbitration, which is also very similar to litigation from the mindset of a student, the salaries would be very nice. There would be a lot of foreign travel. There would be everything fancy about it. So which is not completely false. There is an element of good things and glamour around commercial arbitration, but you must answer this question to yourself first: that am I ready to take that plunge into arbitration, or am I just doing it because it sounds so fancy? There are a lot of other things that you could do. But if you have made a choice, and if you think that you are cut out for it, a few things that you must or you could do is definitely intern at offices that are doing specialist arbitration matters instead of going for law firms who have very minimal practice of arbitration. So for example, Sam has an exclusive team doing arbitration. So if you're interning with Sam, you may want to intern in the division that does arbitration for you to understand what arbitration is all about. There are certain academies around the world which will give you a very good flavor of what arbitration is. For example, Paris Academy is very famous. There is an academy in Germany, Cologne Academy of Arbitration is very famous as well. There are summer schools on arbitration. King's College in London organizes it. Once you have understood that yes, I have to do arbitration, some avenues that may be available for you as a young lawyer other than being an associate with a tier 1, tier 2 arbitration firm is that you could also work in chambers of renowned arbitrators in India and abroad. I know of a couple of students who had interned at my office and are now working at in chambers of international arbitrators in Singapore and London, and they are doing exceedingly well. They're preparing yourself for the big game. Other thing that most students often ignore or are probably not aware of is to act as tribunal secretaries. If you act as tribunal secretaries in international commercial arbitrations or other big arbitration matters, you get to see everything, right from the advocacy, the oral, the written advocacy, how the tribunal is thinking, if there is an expert who's deposing before the tribunal, what sort of things the tribunal is picking from the expert testimony, all of it you learn and you get paid. So I think it really works as a very good launch pad for young practitioners to act as tribunal secretary with renowned arbitrators in India and abroad. Then there are various other things that you could do, right from doing a master's degree in an international arbitration specialized course to take up roles like assistant counsel, which Permanent Court of Arbitration offers. I think this is a very, very good opportunity with many students do not think of. This is a 1 year sort of an unpaid internship at Permanent Court of Arbitration offered to final year students or fresh graduates. The chances of you getting absorbed in PCA are very high if you perform well. And PCA is one of the oldest institutions in the world, headquartered in Hague, where the Peace Palace is. Similarly, LCIA and SIAC offer internships, which are paid internships. ICC offers internships, and more often the former interns who perform well are taken by the institutions as their employees to begin with. And from institution, you could then later on switch to an arbitration practitioner. We have Ajay Thomas, who has done exactly the same. And so there are many others in India and abroad who have taken that route, which is very, very focused and effective.
Thank you for all your guidance. And I had a question for you, is that how helpful is the training? Like Chartered Institute of Arbitrator give training and it starts from student membership and goes up to fellowship. So is it good to be trained and attending those courses at early on so that you start thinking as to how to act as an arbitrator or how to conduct yourself into arbitration matters? Because they are all specialist institutions and they try to impart good training. So what's your view on that?
I think, yeah, this is a very important part of your training as an arbitration practitioner, because even if you join one of the best law firms, I'm sure Tejas does not have time to mentor you if you are a first year associate. He is busy with a lot of other things. So the mentoring you cannot really expect will happen in a full service law firm or a tier 1, tier 2 law firm or in a busy chamber. Yes, you do learn being in those chambers, but that has to be automatic and voluntary learning. Therefore, if trainings like these, like they just mentioned, offered by Chartered Institute of Arbitrators, then there are other trainings. SIAC has started an academy, Singapore International Arbitration Center now runs an academy in India. ICC has a very, very interesting academy also. So some of these trainings could get you, give you the skill set that you require to be a well-recognized upcoming arbitral practitioner and would be very useful for your firm and your employer if you have that skill set early on.
Yeah, and all these institutions have the young members group also.
Yes, yes. Very important is that ICC, CIAC, LCIA, Chartered Institute of Arbitrators, ICA, that is International Center for Commercial Arbitration, all of them have something called their young members group. For example, ICC has YAF, Young Arbitrator Forum. Then ICA has Young ICA, CIAC has YCIAC. All of these memberships are free. And all these events are 99% free events, whether you attend something in India or abroad. This is all the skill training that these institutions are providing for free to all the young individuals, or not so young. Sometimes most of these institutions have the young division which runs up to the age of 40. So you get on within early on, until till the time you're 40, you're still called young member. I have some years to go.
Yeah. What about IAF? Would you like to talk about IAF to this audience? Just
okay.
to introduce. Yeah.
Okay. So IAF, both of us, Tejas and I, are intricately involved with the functioning of IAF. IAF is Indian Arbitration Forum. Some of you might have heard of it. Some of you might not have heard of it. We are in the process of restructuring it and giving it a completely new look, making it more and more useful for arbitral practitioners from India. We did certain events which were similar to what I've been telling you about, giving out necessary skill trainings. We did a Delhi IF launch. We did some events in Bombay and some events in southern parts. We have also taken some sort of some sort of an MOU which we have entered with ComBar, that is Commercial Bar Association of UK. So in future you will see more and more trainings and programs that will be organized and will have support of not only ComBar but other institutions, because they have supported all of our initiatives in the past. IF also came out with a practice guide that was on conduct of arbitration, which is more to do with the arbitrators, how they should conduct arbitration, especially if they are doing an ad hoc arbitration, because there are no set of rules to be followed. And if somebody has something to fall back upon, it becomes very, very useful, because as you've heard and you may know, that many arbitrators are former judges who switch from their judicial work to being an arbitrator and may not have acquired the right skill set. So it's not just for all of you, it's also for the arbitrators to have that sort of skill set to be an arbitrator, which many times they do not really take the time to acquire. So yeah, these guidelines we hope would be very, very useful. And I would in fact ask Tejas to add to it, because he's been equally involved in the development of IF right from the inception.
No, we just wanted to introduce very briefly, because sometimes unlearning is more important than learning. So when you have trained in a judicial mindset for so many years, or the lawyers who are primarily trained in that field, we are trying to make up. And this is an initiative, we all talk about arbitration bar, but somebody has to take initiative. So we want all of you who are interested in specializing in arbitration to join. We are revamping the website and we will try to promote it.
Just one last point which I forgot to mention is that, so commercial arbitration is not the only avenue of arbitration or the area of arbitration. It is obviously one of the most prominent ones and the easiest one for you to get your hands on, because most of the firms do it. But there are many other super specialized areas, including investment treaty arbitration, maritime arbitration, oil and gas arbitration, sports arbitration, and so on and so forth. So please keep your minds open. Look for academies and special courses. Like for construction arbitration, there are some specialist courses that are being offered by universities in Australia. And maybe Mr. Singh may know a little more because of his expertise in construction law. But look at these super specialized areas also, which we often tend to ignore and think that the arbitration, international arbitration, is just international commercial arbitration. That's not the case.
I quite see your point, because Professor Martin Hunter had come to our firm to deliver an interactive session. And we were feeling very proud that we have an arbitration practice group. So he asked a very simple question that before I speak to you anything, raise your hand, how many of you domestic arbitration? So everybody raised the hand. He said, tell me how many of you do international arbitration? Everybody raised the hand. Then said, how many of you do oil and gas? Everybody raised. He said, your group is completely useless. You people don't know how to do arbitration. You do everything. So you need to be super specialist. I said, we are specialists. He said, no, that's not the way. The way you should develop yourself is that within your group, you should have subgroups who do super specialization. The domestic people should not do international. I said, that's not possible. They will ask me to resign if I do that. So that's the level we have to achieve eventually, because that is the only way we will be able to survive in this world. Without taking further time, Mrs. Singh, you had some comments on this.
CIR, this Chartered Institute of Arbitrators UK, which they just referred to, and Sasank also talked about. This is a 104 years old organization, world's one of the oldest organization, which does not administer arbitration, but only trains people for arbitration and gives accreditation, whose accreditation is globally recognized. And anybody who has got fellowship of CIR, he becomes eligible to be on the panel of arbitrators of all internationally recognized arbitration institutions. So that is the value attached to it. It is really gold standard. And in fact, I have been director of CIR in India for long, 11 years or something. And I've been in charge of training in North India. Lot of law students who were interning with me did the associate grade, that is the first grade, they qualified. And in fact, the results we have given for associate grade has been almost 100% here. And thereafter, you can, after you graduate from your law school, you can go to the next level. Another important aspect about CIR training program is, today I think we are suffering from the information, plethora of information you have all around, and then comes the question what to read, what not to read, how to read. CIR has got amazing course material, very focused. They teach you what you should really learn at this stage, and then you have to write exams at various levels. So that is amazing thing you can do. One thing I forgot to mention in my first, when I started on advocacy, a good advocate is one who does hand holding for the arbitrators. If arbitrator is in a problem, if he looks at you, then it means you have proven to be a good arbitration advocate. So you should be aware of all the best practices of arbitration. And another important aspect is your awareness about the soft laws, the guidelines, the protocols. IBA has lot many guidelines and protocols. CIR has lot many guidelines and protocols. ICC has lot many guidelines and protocols. Go to their websites. These are all freely available. Just read them, and so that you are aware of everything. Thank you.
Mr. Pachanda, you wanted to add something?
I wanted to just make 2 points. One, of course, because if we talk about emerging avenues for young arbitration practitioners, I wanted to just bring to your attention about one development which is unique and very different from the way it is in India. I think when lawyers aspire for dispute resolution as a practice option, I think in addition to money and success, it is also a certain degree of distinction as an arguing lawyer that you aspire for. And I don't think in India the trend has yet picked up in terms of designating as senior advocates those lawyers who focus exclusively on arbitration. So when courts start looking at lawyers who have to be appointed as senior advocates, they will still look at lawyers, as of today, who are predominantly present in court. But a trend has started in the UK bar, where they have, as a matter of conscious choice, when they start the process of appointing Queen's Counsel, they have started looking at arbitration lawyers, number one, and not arbitration lawyers in the UK, but worldwide. As a result of which, we now see that counsel who practice exclusively in the area of arbitration sitting in Singapore or Hong Kong might find it difficult to become senior counsel in their own court, but the Queen's Counsel competition in UK will pick out the brightest arbitration counsel in the world and make them Queen's Counsel. So I think that's a new trend which adds another dimension to the attractiveness of being a counsel in arbitration. I mean, I know of 2 or 3 young lawyers, much younger than what you would expect in India for people to be designated as senior counsel. But they've just recently been made Queen's Counsel in UK because of the work that they do internationally in the arbitration space. That is the first point I wanted to make. The second point I wanted to make is when we talk so much about advocacy, oral advocacy, written advocacy, there is an area where you will find that Indian lawyers, even the best of us, have a gap in our training. We are very impressed when we see a Queen's Counsel leading us or opposing us in an international arbitration. But fundamentally, which is the area where that Queen's Counsel is ahead of the top counsel from our own jurisdiction? And you will discover that the art of cross-examination or the science of cross-examination is something that is becoming increasingly rare in civil litigation in India, because you don't see so much of a civil trial, although on the criminal side, you still are trained. If you're a criminal lawyer, you just can't help it but become a good cross-examiner. But on the civil side, if you're a civil lawyer who's decided after 10 years of civil litigation to move to arbitration, I see a lot of gap in terms of training in cross-examination. So in addition to looking for opportunities as young lawyers to pick up information and skills and opportunities about arbitration practice, please also try to avail of opportunities where young lawyers get training in cross-examination. So you will discover that the English bar runs short-term courses, training in cross-examination. The Singapore Law Society runs short-term courses in cross-examination. And if, some of you might want to spend time in observing a hearing in the Supreme Court, if you get an opportunity, please go and observe a good cross-examination in any other jurisdiction, including India, wherever, because I think that is a skill that will completely change the complexion of an arbitration practitioner if he's well versed in cross-examination. Thanks.
That's very helpful, because sometimes in cross-examination we don't know what not to ask, and that's the skill which all of us need to learn, because as Mr. Singh said, it's an art and science both. And if we don't, what we have seen of late is in civil cross-examination, in civil litigation, we see that we put the case to the witness, that I put it to you or I suggest to you, whereas in international arbitration, that's not required. You only focus on something which is what is required to be asked. And in related to that, Mr. Singh referred to the cross-examination. So if I may ask a question, that in international arbitration, we follow a chess clock method. So what is that, if you can explain to all of us?
One of the difficulties what we face here in our jurisdiction is that I'll give you one example of international arbitration I have been involved in. Only last Monday it got over. I cross-examined for 23 days. It was not whole day, it was 2.5 hours in the evening, but 23 sittings. And final submissions, I argued for 16 days, 16 sessions. If I would have been arbitrator, I would not have let that happen. But sometimes this does happen, because arbitrators have their own difficulties. When we talk about Indian arbitration, sometimes they say, we will sit only in the evening, you can't help it. So obviously, in ideal setup, arbitration hearing should happen in one go, which would start from the opening statement, examination in chief, if you don't have witness statements in place, and the cross-examination, closing statements. Hearing, this is what hearing means in arbitration, this is how it should happen. Now for that, you will have only one hearing schedule fixed. That will be, going by the thumb rule, it is 7 days. You can have 10 days, you can have 5 days, depending on the nature of the dispute. So when parties are traveling from all across the globe, 3 arbitrators are coming from 3 countries, you have time. Time is money there, because for every day spent by all the people there, it is costing a lot of money. So question is how to discipline the process, and for that there is a method called chess clock method, which is very, very popular method in international commercial arbitration world, where arbitrators well before the hearing will decide how many hours are to be given for the hearing, depending on the nature of the dispute. If you have 8 days or 7 days, 6 hours per day. Now you have, let us say, 42 hours. They will say, we have got, ladies and gentlemen, we have 42 hours. Now going by the chess clock method, what we are doing is we are giving 21 hours to one side and 21 hours to the other side. Sometimes some arbitrators may say that depending on the number of the witnesses who are to be cross-examined, we can give one side more. But again, there is dispute about, there are two schools of thought. Without going into that aspect, now let us assume that you have 42 hours, 21 hours to each side. Now within those 21 hours, it is for you to decide how you want to use those 21 hours. Whether you want to use it for cross-examination of one witness, two witness, three witness, you want to retain it for your closing submissions, you want to retain it for your opening submissions. So this is where a lot of discipline is required on the part of the lawyers, and lawyers are to be really very well trained. In fact, invariably what we do is, we will have one of our colleagues who will be keeping eye on the watch. We have to plan ourselves in such a way that within 21 hours we must do whatever we have to do. In fact, I had a arbitration seated in London. I had to cross-examine 4 witnesses. Other side had to cross-examine only 1 witness. I had to do I had to do opening, I had to do closing statements. Now, for me, it was a bigger challenge, but we managed to do, and we had to decide how many hours you want to put to one particular witness who is really the most material witness. So, and again, other side had the same amount of time within which he had to cross-examine only one witness. So, chess clock method is very popular method where times are allocated to the parties, and you have to decide how you want to use that particular method. Thank you.
Thank you. Do you have any questions? Yes, please.
So sir talked about the case management system right now. So I just have one question, that has there ever been any challenge to this case management order itself, which basically delineates the number of hours that you could represent your case, or which has limited the number of witnesses? Because the parties can later say that because of that I didn't get a full opportunity to present my case. And my second question is that, is it expected of the tribunals to frame the issues upfront so that the parties can address that issues accordingly?
The first one.
Challenge to call case management procedure. First of all, we need to know that, understand that it is all about the arbitrator's ability to really go for this case management, where essentially and invariably in every case arbitrator will take the both sides along. So therefore chances of challenges to these kind of procedures are almost nil, because both sides will agree to the timeline which is being agreed, and this is where arbitrator's skill and particularly chairman's skill comes in play. So therefore, to say that challenge to case management, it is very rare. At least to my knowledge, I haven't come across any situation where case management orders are challenged on the ground that one party has not been given enough or adequate opportunity. Now, there was another question you asked about framing of issues. The framing of issues or point of determination is something which happens invariably in commercial arbitration or international arbitration in all its forms. But it is not necessary in that sense. It is just for the ease of the parties, ease for the tribunal to be focused on the real issues which really parties are confronted with, that you go and frame the issues. It makes life easier. In fact, ICC has something called term of reference, TOR. In fact, DIAC, Delhi International Arbitration Center, also has procedure for TOR. In fact, if you ask me, and if we have to really help arbitration regime in India, I would make this TOR compulsory for every arbitration. Because term of reference is a paper, a document which is to be prepared by the arbitrators at the very initial stage of arbitration, And tribunal members cannot do this unless they would have gone through the whole file, understand the real issue involved in that. But there are cases where even I had occasion sitting as arbitrator where we have said that we are not framing issues. It is very easy. Parties have understood what the real issues are. So sometimes arbitrator will say that all the claims will be treated as the issues. So point of determination makes the life easier for all the parties because you have crystallized the real issues if determined is going to decide the case. So your cross-examination is focused, your oral submissions are focused, your post-hearing briefs are focused.
Hi, just to clarify your query on the first question, as Mr. Singh pointed out, that the case management hearing is usually fixed with the consent of the parties. But if for any reason, while the arbitration proceedings are going on, and one of the advocates feels that he may be committed to less number of witnesses or less number of hours, in case he feels prejudiced by that case management hearing, he must immediately file an application before the arbitrator seeking a revision, whether in the increase of list of witnesses or seeking an increase in the number of hearings he wants. If he does that, the arbitrator will have to pass an order on it agreeing to extend the hours or giving him limited hours, because even the other side will get an opportunity. In this manner, your concern would get addressed, because either you would have justified increasing the number of witnesses, or the arbitrator will give a reason why he finds your application to be frivolous. Then, of course, if you want to challenge the award on these grounds, it would be available to you on the basis of the application you file. Because all what you're asking is based on the issue of principles of natural justice, which is really the only rule of law which the arbitration proceedings must follow, that it must follow the opportunity of equal hearing to all the parties.
Thanks. And one thing I found recently, we did one hearing in London where at the end of the arbitration, the arbitral tribunal was thanking all the counsels for their help, and in passing they mentioned that hope you were given full opportunity of hearing. And obviously at that point everybody says yes, and these are all the hearings which gets recorded by way of a transcript. So it's very smart on the part of the tribunal to get an undertaking from the counsels that you were given full opportunity of hearing, and that's get recorded in the transcript so that tomorrow nobody can challenge that. Of course you can challenge it, but the other side will obviously show that no, tribunal asked you that you got complete opportunity to present your case.
Maybe a hack to that would be just smile and don't answer, so it doesn't come on the transcript.
Yeah, that's a good suggestion. Any further questions?
My question is to Shashank sir. Sir, I would just want you to elaborate on what Tejas sir asked you to address about if we should actually do litigation and arbitration both together. I mean, ma'am also mentioned that it's very difficult for us to have feet in both the boats. So that is one thing. The other thing is that when you spoke about how we should judge whether we're actually interested in international commercial arbitration as a career, is that we should try to find out if we have the aptitude for that. So if you could elaborate on how we could do that. Thank you.
So on the first question, or let's start with the second question first. So how do you find what's your aptitude? The idea of doing internships throughout your course, that is the 5-year course, is to not to select the areas that you're comfortable with, but to eliminate the areas where you feel that I'm not cut out for this. That's my approach. But sometimes I feel that students do the other way around. They like an office. They possibly would have worked on a particular case which they found was very, very interesting, and just get hooked onto this idea in their head that this is my calling. I'm going to do this when I become a lawyer. I think that's a very dangerous approach. The wiser approach would be to eliminate areas that you're not comfortable with and see if you're somebody who likes disputes. So disputes practice, I mean, broadly you can find out if you're a disputes lawyer or a transaction lawyer by seeing your comfort with doing moot courts, arguing in front of jury. I mean, if you're more of a research-oriented person who likes to who likes to be in office, analyze things in detail, who gets interested in transactions, etc., then you know really early that maybe I am more suitable for a job which leads to something in capital markets, private equity, etc. But if you feel that you like your day in court, if you think that that's something that gives you more satisfaction, then yes, you have the aptitude to be a disputes lawyer. Then on the first question, whether you could do both litigation and arbitration, yes, many of us do that. I think she would agree, she's been doing that, and that used to be the classic approach. Most of our arbitration lawyers in last few decades were litigating lawyers or continued litigation while doing arbitration. But as you see now, the amendment in the act and the international best practices are being followed. The time restrictions are taking a toll on not only the arbitrators but the advocates, who would require a lot of time earmarked for a particular arbitration case, which is not possible if you are a busy litigating lawyer. I'm not saying it's impossible, but then possibly you may not do justice to either side, either your litigation matters or the arbitration matter. So it's better to get focused, but that does not mean that you still cannot do litigation and arbitration both. If you do that, then possibly the amount of arbitration work that you do, you will have to restrict that to a certain number of cases only. But if you want to get focused on arbitration, eventually, even if you join a chamber that does litigation, you may want to slowly make that switch.
Actually, this is very interesting question, and just to add to what Sasank has said, my personal understanding is that it always helps if you have some experience, reasonable experience of litigation. When you start your career, people are not going to come to you with big arbitration, commercial arbitration, investment arbitration. But smaller cases, 138 cases, summary suits, these are the kinds of cases which will come to your table very frequently. My sense is, even if you want to go for arbitration completely, that is what you have decided for yourself, still, you must have some experience of court litigation. This is where you understand how courts think, how judges think, how they behave, and that helps you immensely in your arbitration. That is one thing. Secondly, on aptitude, you will agree with me, if in a particular semester of yours, if you have 5 teachers, teacher who teaches you better, and teacher who creates better interest in a particular subject, you start thinking that, hey, that is the subject I should go for. Or if you go for your internship, and I have seen many kids coming to me in my chamber, and if they have worked with me for a month or so, they say, sir, I want to become an arbitration lawyer. So if you have gone to for 5, 6, 10 internships, this is very typical that if you had a good teacher as a lawyer where you have interned, if he has given you some time, he has taught you something, you decide for yourself, now I'm going to become X class of lawyer. This is understandable to a certain extent, but as Sasank said, you first decide for yourself. You see whether you can really do justice to that branch of law. It is really within you that you can take that forward.
We are running out of time, so maybe after the thing. So with that, I thank all my panelists for excellent interventions and suggestions to all of us, and giving a lot of practical tips and suggestions. I would now request Mr. Subhajyoti Gupta to give the concluding remarks. Thank you.
So, like all good things, this conference also comes to an end. I would like to put some of my perceptions that I carry home from this. To me, ADR is about an ecosystem. See, in an ecosystem, you have like these 2 elements. One is the element of hardware, which is the law and the institutions. The other is that of the software. It's how people actually behave. So I remember in 2010, when I was in the beginning of my academic career, I went for a conference in Taiwan where they had actually asked me a very direct question. I think I wrote an article on anti-arbitration injunction or something like that. So a Hong Kong-based lawyer asked me point blank direct that in view of all these cases, why are the Indian judges so hell-bent to sabotage the Indian Arbitration Act? To this, I had given a very complex answer stating, oh no, it's not well drafted, maybe we are developing this, that. But in heart of my heart, I know that this is not correct, right? It's not that every other act in India is like so very well drafted that you cannot really question it, right? Even if the act was problematic, we could have worked with it. If you just look into the Bhatia series of judgments, you'll see that when you have this kind of a just forced argument, you can actually smash through any statutory language. It doesn't matter, right? So, and it has also perplexed me this, I mean, why are we so concerned with public policy? Is it that in contracts, Indian judges are generally, in any arm's length contract, that Indian judges are very interested in public policy? Isn't the Indian judges, like all common lawyers, taught that the public policy is an unruly horse? By the way, public policy is an unruly horse in England because horse is the largest animal that you can find in England. But in India, it's definitely an unruly elephant, right? So what had happened is basically at some point of time that our system lacked a sense of commercial conscience. And this is why, even though we had this hope and we had this dream of making India a hub of global arbitration and mediation, this hasn't really happened yet. But the happy part is that things are changing, and I think our judges, our system participant at all levels is actually developing that commercial conscience. New generations of students and new generations of practitioners are coming in who are more in line with the international system and who would eventually take us there. Another just point I wish to make about ADR is that ADR is not, I do not see ADR as a detour system. In a sense, we are not using ADR because our courts are full. Because you know what, if that was the case, we would all, it would all our efforts be defeated, because it will, at some point of time, we'll have to go back to this overcrowded courts. Because I remembered, I just make the reference, Section 29A that had laid down a timetable for arbitrations, had also laid down many other time frames in many other sections of that, including the applications under the Arbitration Act that the court will have to decide. So it's not that like only Section 29A will expedite arbitration. It will have to work with these other sections as well, right? I see ADR more as a sort of as a method to protect a party's interest. Now, what is your interest is basically a subjective matter. You would have to decide how you protect your interest. Will it be through an adversarial process like arbitration, through a more amicable process like mediation, or some in-between hybrid process like, say, argument, right? So once we have developed, like for me to develop India into a hub of ADR, what would necessarily would have to happen, that this full spectrum of choices will have to become available to the parties. And I think at some level we are getting there. I think this conference is also a work in the progress in that direction. So I would like to thank everybody for participating in this conference. I would like to thank our speakers who took their time out of their busy schedule for us. I thank the students for their enthusiastic participation. I thank the team in Shardul Amarchand for putting together such a wonderful program, especially Mr. Karya, Surjendu, Avlokita, Juhi, Ritika and Anirveda, who have worked with us in this project. And I also thank the Jindal team, especially the events, communication and media and their cooperation, and a special thanks to Ashokji for helping us out here. And finally, I thank my colleagues in CADR as well as the student board of the ADR Society, especially the members of our ADR Society Board that are here, Malika and Achinta, as well as our students Kainath and Romit. I hope you have all enjoyed this conference. Thank you for participating so much.